Hello, we want to do some more practice questions. Seems to be a very common thing that a lot of people like help with, just to go through some review, do a little practice, see how we stand in certain areas. And in this particular review, we're going to be looking at some questions dealing with some primarily agency relationships or brokerage relationships in general. But let's just go through a few questions and see how we do, see if this will help us out any. First question, which of the following would be considered dual agency? Well, let's see. A broker acting for both the buyer and the seller in the same transaction. Sounds pretty good. B, two brokerage companies cooperating with each other. Well, we know that's not what dual agency is. C, a broker representing more than one principal. No, because dual agency has to be in the same transaction, right? And then D, a broker listing and then selling the same property. Not necessarily. D potentially could be, assuming he was representing the buyer as a client, but it doesn't say that. It just says he did sell the property, but the buyer potentially could have been a customer, so that wouldn't be dual agency. So I think the best answer, obviously, would be A, when you're representing both the buyer and the seller in the same transaction. That's dual agency. Next question, the relationship of an agent to his or her client is that of a. Now, first of all, you notice I underlined the word agent in this question because, when it comes to the exam, it's really important to use the proper vocabulary, okay? We say things and use terminology in our day-to-day just speaking and talking, we're on the streets, that may not be the right words, okay? So just to be clear, if you have a real estate license, most people refer to themselves as an agent. I'm a real estate agent. But technically, legally speaking, the agent is always the broker in charge, right? So whoever the broker in charge is, that's the agent. Again, technically, if you're not the broker in charge, you're not an agent. You're a sub-agent. We don't use that vocabulary when we're just talking in general. I get it. But for test purposes, you got to make sure you understand there's a difference here. So again, the question is, the relationship of an agent, the broker in charge, to his or her client is that of a trustee, sub-agent, fiduciary, or attorney in fact. Well, when you are, obviously because it says a client, so that means we have an agency relationship. And by definition, agency is a fiduciary relationship, right? So I would go with C. Very good. Fiduciary would be the right answer for that one. By the way, what is fiduciary? What does fiduciary mean? I will tell you, depending on the context in which you're using it, because it could mean a few different things. But in context with what we use it for in real estate, it's basically, in fact, if there's one word I could just throw out there, I'd say legal. So when you enter into a fiduciary relationship, it's a legal relationship that carries legal obligations, responsibilities on both sides, one to each other. Or sometimes called fiduciary duties. Those are those legal obligations. All right, next one. Well, hope I didn't give away the answer. But anyway, a broker is permitted to represent both the seller and the buyer in the same transaction when? Now, obviously, we're talking about dual agency. To represent both seller and the buyer, that would be dual agency. Well, when are you allowed to do that? Well, A says when the principals are not aware of such an act. Well, that's not right. B, when the broker is a sub-agent rather than the agent of the seller. That's totally irrelevant. because we know the relationship's always between the agent and the principal. Subagent's got nothing to do with it, not with this relationship. C, when commissions are collected from both parties, compensation has nothing to do with dual agency. D, both parties have been informed and agree to dual agency. I think that's probably the best answer, because the law says we must disclose dual agency to both parties, explain it to them. That's part of the informing them on what dual agency is. And as long as they're okay with it and agree to sign a dual agency agreement, then you can do it. So in this question, the answer is D. Very good. Next question. An agent cannot legally collect commissions from both the seller and the buyer without. Let's make sure we understand what this question is asking, because I will tell you, you're going to see stuff like this on the exam. It says an agent cannot legally collect commissions. Another term for that might be compensation. Okay? Doesn't even have to be money. Okay? If I give you something of value in exchange for a service, that's compensation. Doesn't have to be cash or money. So anyway, an agent cannot legally collect commissions from both the seller and the buyer without. A says, without notifying both parties of this fact orally after the sale has been closed. I'm going to tell you, the word orally should stick out like a sore thumb. Certainly in South Carolina, pretty much anything you do in regards to real estate must be in writing. So the fact that it says orally, nope, I don't believe that's a good answer. B, notifying both parties of this fact in writing after the sale has closed. What good does that do anybody to disclose anything after it's over? That can't be a good idea. C, can't do it without exclusive listing agreements signed by both the seller and the buyer. Let's look at what D says. Without having the prior knowledge and written consent from the seller and the buyer. I like that one. What the law requires, you must disclose any form of compensation or commission from more than one party. Okay? So can you collect commissions from both the seller and the buyer? Well, you can if it's disclosed, right, in writing, but all parties. You got to make sure all parties know that you're receiving compensation from more than one party. And as long as everybody agrees to that in writing, then it's okay. But it is illegal without having the prior knowledge and written consent of both the seller and the buyer. Okay? Hopefully that makes sense. Now we'll take, I've had people that, well, when would that happen? Why would you receive compensation from both the seller and the buyer? There's all kind of reasons. You could maybe in your buyer's agreement, and just for example purposes only, not to make any kind of suggestion what you should or shouldn't do, but maybe you had in your buyer's agreement that you agreed to represent the buyer for 3% of whatever the sales price is of whatever property they buy. So in other words, the buyer's agreeing that you should get 3% of the sales price as compensation. Well, the house they decide to buy, the seller is only, the listing agent is only offering, say, 2%. So in this case, all right, well, I'll accept the 2% the listing agent's offering, but buyer, you're going to have to pay this other 1%, right? But I will tell you a more common example of where you can get in trouble with this is when you'll see, and this is very common, a lot of times you'll see in the MLS, they'll have like in the remarks section, you'll see that what the listing agent is offering the cooperating agent, the buyer's agent, how much they're willing to pay them, a percentage or whatever. But then it'll also say in the remarks section that we're offering a $2,000 bonus, to the agent brings a buyer before the end of the month, or something like that. Well, first of all, who's paying the commission? The commission's coming from the listing agent typically, right? The listing agent negotiates with the seller to pay X amount of commission to the listing agent, and then the listing agent agrees to offer some portion of that to the buyer's agent. So your commission's coming from the listing agent. Now, if they're offering a bonus, in this case a $2,000 bonus, this is over and above the commission, who's paying the bonus? That's coming directly from the seller, okay? That's two sources of compensation, which is in line with what this question is asking. In fact, the way the law reads here, it says it would be illegal to receive compensation from multiple or more than one source without the full knowledge and consent of all parties. And obviously that's written consent. So you'd have to disclose to the buyer that if you buy this house, I'm just letting you know, the seller's offering a $2,000 bonus on top of the commission if you buy this house. I need to disclose that to you, buyer, before you make the offer. Are you okay with that? And they need to sign off whether they are or not. And I will tell you, don't be surprised. My guess is most buyers would probably say, no, I'm not okay with that. I wouldn't. I can tell you right now, if I'm your buyer, that ain't happening. In fact, I would just tell you straight up, why don't you just accept the commission you and I both agreed to, tell that seller to keep their $2,000 bonus and take it off the price of the house. Why don't we do it that way? That's what I would prefer. Now, having said all that, as long as you get the written consent from all parties, then you can go ahead and do it. But without that, it's illegal. All right, the next question. Which of the following best defines the law of agency? All right, well, A says, the selling of another's property by a properly licensed brokerage company. Doesn't sound like agency to me. B says, the rules of law that apply to the responsibilities of a person who acts as an agent for another. That's getting pretty close. C says, the principles that govern one's conduct in business. No, that doesn't sound right. The rules and regulations of the state's licensing agency. No. Again, the question, which of the following best defines the laws of agency? And again, going back to B, it says the rules of law that apply to the responsibilities of a person who acts as agent. Remember, who's the agent? The broker in charge for another. I like that one. I think B in this case would absolutely be the best answer. Again, by definition, agency, that relationship is between an agent and the principal. And obviously the laws of agency lay out what those duties and obligations are of both parties that are in this relationship. So again, B, the rules of law that apply to the responsibilities of a person who acts as an agent for another. Next question. Broker Jones shows properties listed for sale with her company to prospect Carl. Carl has refused buyer representation. This should be a pretty easy one. So Carl is Jones what? Well, obviously, A is not right, client, because they refused representation. B, principal. You could make a case, an argument that Carl would still be a principal to the transaction, okay? But C, customer, I think that's a much better answer. And then D, fiduciary, we know that that only exists with the agency relationship. Carl's refused that. So we know it's between B and C, and I'm going to tell you this is a good example of a point I need to make right here. I believe that either B or C technically could be right. However, and I've said this in other videos where we're doing practice question stuff, but let me just say it now. On the state exam, when you go to take the real estate exam, this is something you better pay attention to, because what the instructions you're given is to read the question and select the best answer. It does not say read the question and select the right answer. That's different. The right answer could be different than the best answer. In this case, you could probably argue the right answer could be B or C in this example. But they're not asking for the right answer. Even though in this case there may be two right answers, only one of them's the best answer given this question. All right? And I can tell you, in South Carolina, you're either going to be a client or a customer. Those are your two options, right? Well, we know they're not a client because they refused representation. So, to me, the best option here would be customer, okay? But honestly, whether you're a client or a customer, you're considered a principal to the transaction. That's why principal could technically be a right answer, but it's not the best answer given this question. And that's the kind of stuff you better pay attention to on the exam, which honestly is what gets people really confused and uptight, because they'll look at a question and say, well, it could be B or C. That's not fair. Either one of them would be right. Okay, well, they didn't ask you for the right answer. Again, make sure you understand what they're asking in the question, and then choose which one of the right answers would be the best answer for that question. You got to look at it that way. All right. In South Carolina, when may an agent divulge client confidential information? This is a good question, and any of these are good questions, but you better make sure you're ready for this for the exam. Let's see. A says never, since the client confidentiality must be preserved indefinitely. That's not necessarily true. B, when a relationship with a client is limited. Don't really like that one. C, in a disclosed dual agency situation. Absolutely not. D, if required by law. There were, and I'm not going to start teaching right now, but in the law, if you recall, it identified there are 3 times when an agent can disclose confidential information, okay, of a client. And one of those 3 is if the disclosure, whatever it is required by law. Just for example, by the way, let's make sure that's the right answer, and it is. If it's required by law, and I've had this happen many times where I'm sitting down maybe in the kitchen at their kitchen table, signing the paperwork to get the property listed, put it on the market. And as we're going through all this paperwork, several times I've had stuff say, now Frankie, I will just go ahead and tell you, just so you'll know, if it should rain like really, really hard, the roof might leak just a little bit in this far back room. But it's really not a big deal. But I'm just letting you know that. And like every time I said, well, seller, I appreciate you letting me know that. Now that is something we will have to disclose to potential buyers. And honestly, and I've had them come out and say, oh, no, don't you do that. I only told you that because you're my agent. And I expect you to keep that confidential because you are my agent. You start telling buyers that my roof is leaking, there ain't nobody going to be buying this house. So I want that kept confidential. So they're telling you to keep something confidential. The problem is the law in South Carolina says you must disclose all known defects. You can't keep that confidential. The law says it has to be disclosed. So, client, you can't tell me this is confidential if the law says I have to disclose it. I got to comply with the law every time, right? Okay. Next question. A buyer prospect is interested in seeing a house listed with the real estate company but does not wish to enter into a buyer agency agreement. The salesperson from the real estate company can show the buyer a listing if, A says, if the salesperson obtains the seller's permission, B, if the buyer verbally agrees to buyer agency. Well, y'all, there's that oral or verbal again. We know that's probably not going to be right. C, if the buyer wishes to remain a customer. And D, the salesperson provides the buyer with a dual agency consent form. Well, we know D's not right because they've refused representation altogether. And you can't have a dual agency until you have two single agency relationships, right? So I'd have to have a listing agreement with the seller and a buyer's agreement with the buyer where now I'm representing both parties. Then if they choose, I could now represent them both in a dual agency if they want to sign the dual agency agreement. Well, if one party has not signed an agency relationship to be your client, there's no way you can be a dual agent. So D is out of the question. So given the options here, I think C is the better answer, as it says here. But a salesperson from the company can show the buyer the listing as long as the buyer wishes to remain a customer. As long as you've explained it to them, you're a customer. I cannot represent you. I cannot offer advice. I cannot offer any opinions. Basically, you're on your own. I can help with some administrative or ministerial things, but that's all I can do for you. As long as you're okay with that, buyer, we can do it. All right. Next question. How is a broker's commission determined in a real estate sales transaction? Let's see. A says it must be stated in the listing agreement and is negotiated between the broker and the seller. Okay. B, it is determined according to the standard rate set by agreement of the local real estate. Well, we know that's not wrong or not right. We know that would be a violation of antitrust laws, right? We know commissions are always negotiable. C, if under dispute, it will be determined through arbitration by the real estate commission. It says in the law that the real estate commission will not get involved or be involved with commission disputes and stuff like that. So don't think that's it. And D, it must be paid with cash or a cashier's check upon closing. No. In fact, we kind of touched on it a little bit earlier. The commission or compensation, it doesn't even have to be cash. It could be anything of value. So, obviously the best answer is A. It must be stated in the listing agreement and negotiated between the broker and the seller. And that's what we do. Commissions are always negotiable between the agent, or in this case, broker, and the seller. All right. Next question. The dual agency contract needs to be signed by, again, that's the dual agency contract, signed by A, the seller at the time of the listing. Don't think that's going to work. B, both parties before closing. C, the seller after the offer is presented. I don't like that. Or D, both parties before a specific transaction. So what do you think? Yep, hopefully you said D. Because, here's where we've seen a lot of problems here. a lot of agents have gotten in trouble over this on when the dual agency agreement needs to be signed. Let me just give you a real quick example or scenario here, and this will help you for test purposes, I promise you. But y'all say I've listed this house for sale. I've got a buyer contacts me. Maybe they see my sign in the yard or whatever. So they call the number. They contact me. They'd like to go see the property. Now, for me, I always, I'll go ahead and disclose agency to them, even though at this point, this buyer is a customer, right? They have not become my client yet. But then I will, after we meet, I'll disclose to them the agency relationships or the options of the different brokerage relationships that are available. But basically, let them know I can represent you in this transaction as long as both you and the seller agree, because you need to understand I'd be representing both you, buyer, and the seller. So I'm representing both of you in this same transaction. Or buyer, you could be a customer. Well, let's just say, for argument's sake, the buyer says, well, no, I don't know what I'm doing, so I want representation, and frankly, I trust you. I want you to represent us. Okay, well, what'll happen a lot of times here is, the agent will go ahead and get them to sign, actually, a couple problems here. They go ahead and get them to sign the dual agency agreement and then write up an offer. Go ahead and write up the offer. And then we go see the seller. I've got the dual agency agreement signed by the buyer, and I've got their offer. But when I get to the seller, I say, no, seller, I've got a buyer that is wanting to make an offer. But this buyer is also my client, and this would be dual agency if you agree to move forward. Again, got to make sure everybody understands what we're doing here. And assuming in this example, the seller says, okay, then the agent will go ahead and get the seller to sign the dual agency agreement. And I've got it signed by both parties. And then we'll go ahead and present the offer. That is wrong. You cannot do it that way. Two problems here. Number one, did you get the buyer to sign a buyer agency agreement before they sign that dual agency agreement? Okay? And I said just a few minutes ago, you cannot have dual agency without two single agency relationships. So you can't bypass one, you can't bypass the single agency to get the dual agency. So make sure the buyer signs the buyer agency agreement first, and then they can sign the dual agency agreement. The second problem is you cannot ask the buyer what they want to offer before you know if you can represent them, right? That's a no-no. You don't know if the seller will agree to dual agency at the time the buyer agreed to dual agency. So assuming we got the buyer to agree to it, they signed it, then you got to say time out. That's as far as we can go right now, buyer. Let me go talk to the seller, make sure they're okay with the dual agency, and then I'll be back in touch. Now, assuming the seller's okay with it, then they'll sign it. Now you go back, now that you got the dual agency agreement signed by all parties, now you can go back to the buyer and have them write up the offer. But you cannot solicit from a buyer what they would be willing to offer, and you don't even know yet if you can represent them. That's a no-no. So, don't put the cart in front of the horse, right? Let's keep that straight so we don't have any problems here. So, when does it need to be signed? By both parties before any specific transaction. Make sure that's all done up front and first. I hope this was helpful to you. We'll have a part 2 and do some more review questions coming up. But in the meantime, shine for Jesus.